Hello, we are Team Marshall, and we will be presenting the Gilmer versus Interstate/Johnson Lane Corporation case argued and decided in the United States Supreme Court in 1991. Interstate Johnson Lane Corporation defendant hired Robert D. Gilmer, petitioner, as a manager of financial services for their company. Gilmer, as required by his employment, registered as a securities representative with several stock exchanges, including the New York Stock Exchange. His registration application included provision to the effect that he agreed to arbitrate any claim which arose between him and Interstate, which was required to be arbitrated under New York Stock Exchange Rule 347. This rule provides for arbitration of any controversy arising out of a registered representative's employment or termination of employment. In 1987, Gilmer was terminated from employment at age 62. Gilmer filed an age discrimination charge with the Equal Employment Opportunity Commission and filed suit against Interstate for age discrimination, claiming that the company had violated the Age Discrimination and Employment Act of 1967, or the ADEA. In response, Interstate filed a motion to compel arbitration, citing the agreement that Gilmer had made to arbitrate any controversy arising from the termination of employment. The district court denied the motion, finding that under the United States Supreme Court holding Alexander versus Gardner Denver Company 1974, Congress intended to protect ADEA claimants' access to the courts and expressed that under the ADEA, claimants would not be denied access to the courts. The case was appealed and then reversed in the Fourth Circuit of the United States Court of Appeals. The appellate court expressed the view that nothing in the text, legislative history, or underlying purposes of the ADEA indicated a congressional intent to prevent the enforcement of arbitration agreements. Gilmer appealed, and the United States Supreme Court granted certiorari. The U.S. Supreme Court affirmed the appellate court's decision. Next, Juan will discuss the petitioner's arguments.
Gilmer posed 5 main arguments. The first argument was that compulsory arbitration of ADEA claims pursuant to arbitration agreements would be inconsistent with the statutory framework and purposes of the ADEA. Because the congressional intent to preclude waiver of the judicial forum can be surmised from the role Congress has established for the Equal Employment Opportunity Commission, the EEOC, in the enforcement of the ADEA. The second argument was that arbitration will undermine the role of the EEOC in enforcing the ADEA. Since if arbitration agreements are enforced, the EEOC will no longer be able to function as a protector of the employee rights under the ADEA. Also, because the ADEA empowers the EEOC to investigate age discrimination claims and to bring enforcement actions to ensure that companies comply with the state's provisions. Thirdly, the ADEA is designed not only to address individual grievances, but also to further important social policies. Another argument is that the compulsory arbitration is improper because it deprives claimants of the judicial forum provided by the ADEA. Another argument is the arbitration procedures are inadequate for the resolution of his claim because the arbitration panels will be biased in the following ways. Firstly, that discovery allowed in arbitration is more limited than in the federal courts, which would make it difficult to prove discrimination. Also, that arbitrators will not issue written opinions, resulting in lack of public knowledge of companies' discriminatory policies, an inability to obtain effective appellate review, and a sitting of the development and a stifling of the development of the law. Also, because arbitration procedures cannot adequately further the purposes of the ADEA because they do not provide for broad equitable relief and class actions. Also, that there will often be unequal bargaining power between employees and employers. The final arguments cited 3 previous cases that would preclude arbitration of employment discrimination clauses. The first was Alexander versus Gardner Detroit, in which an employee required to arbitrate under a collective bargaining agreement was entitled to a trial in novo in his Title VII claim, despite having lost at arbitration. The second case cited was Barentine versus Arkansas's Best Freight Systems, in which a claimant under the FSLA was not barred by the unfavorable decision of an arbitration. And the last case cited was McDonald versus City of West Branch, where an arbitrator's decision on a Section 1983 claim has no collateral estoppel effect. Next, Morgan will discuss the appellate's arguments.
As previously stated, Interstate Johnson Lane Corporation required Robert D. Gilmer to register as a securities representative with, among others, the New York Stock Exchange upon his hire. This registration also contained a statement that Gilmer agreed to use arbitration when a disagreement arose between himself and the company. This agreement was covered by the New York Stock Exchange Rule 347, which states that arbitration is to be used over any disagreement arising from a registered representative's employment or termination of employment. Interstate Johnson Lane Corporation relied upon this arbitration agreement in the Federal Arbitration Act while filing motion to compel arbitration of an ADEA claimant, Gilmer. The district court denied this motion based on the ruling from Alexander versus Gardner Denver Company, stating that arbitration was inadequate for the resolution of disputes arising from violations of the Age Discrimination Act and Employment of 1967. They also expressed that Congress had intended to protect ADEA claimants from the waiver of a judicial forum. On appeal, the United States Courts of Appeal reversed this decision, stating the view that nothing in the text, legislative history, or underlying purposes of the ADEA indicated an intent to preclude the enforcement of arbitration agreements. The United States Supreme Court affirmed, stating that the individual's termination of employment claim under the ADEA could be subjected under the FAA to compulsory arbitration pursuant to the arbitration agreement in the application. Next, Donald will discuss the analysis of the
After hearing the arguments from both sides, the court deliberating came together with a decision. The termination of employment claim could be subjected to arbitration due to the arbitration agreement. This decision was ultimately made due to the 6 following points. Number 1, the burden of proof was not met to show that Congress had intended to preclude arbitration claims under the ADEA. Number 2, nothing in the text of ADEA explicitly precluded arbitration. Number 3, such arbitration is not consistent with the framework of the ADEA. Number 4, the claims on the adequacy of the arbitration were insufficient to preclude the arbitration. Number 5, there is no evidence that the individual is tricked into agreeing into arbitration. And the last point is the prior Supreme Court cases involving arbitration contained nothing that would lead to this particular arbitration being precluded. With all these points together, the court was able to make and support their decision. Now Ryan will discuss the significance of the court's decision.
So when one looks at arbitration, they can divide it into 2 time periods, pre-Gilmer and post-Gilmer. Before Gilmer versus Interstate, the Supreme Court generally disfavored binding arbitration as a means of settling disputes between employers and employees. After the decision, the Supreme Court was willing to allow arbitration in an employment context, not just commercial contracts. In terms of social significance, there is the potential for this case to affect pretty much everyone that works for a living, whether it be a manager, supervisor, or rank-file employees. For those people who have a desire to work in only a certain field, such as Gilmer in this case with securities, they would have to give up their right to ever go to court, which could turn some people off. Also, employees that prevail in arbitration are awarded their damages in less time than they would had they gone through the court system. Moving on to business significance, people might not be willing to consent to arbitration, therefore businesses could lose potential employees. Also, mandatory arbitration could cut down on litigation costs as well as other costs. Mandatory arbitration can also streamline and shorten the claims process, thereby freeing up some money for companies. Also, by having arbitration with a specific plan, a company could have a bit of an advantage in the change of forum as opposed to the court system. And last up is Donald again, who will summarize the case for us.
At the conclusion of the case, Gilmer appealed and the United States Supreme Court granted certiorari. The U.S. Supreme Court affirmed the appellate court's decision. This is a case that, as mentioned, has a lot of social significance and will be referred to anytime an arbitration agreement arises. Thank you, and I hope you enjoyed our presentation.